Today, we step inside Judge Raquel West's courtroom, where 4 defendants learn what happens when second chances run out. From probation violations to evading arrest, this isn't just about punishment, it's about accountability, delivered straight and unfiltered. Stay tuned, every verdict in this room tells its own story.
All right, sir, again, you're Jerry LeBlanc?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
We do, yeah.
Hey, y'all, I'm still going. Sorry. Let's see. Mr. LeBlanc, in cause number 21-38605, you're charged with the state jail felony offense of theft from August 27th of 2021. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Yes.
And then in cause number 22-40408, you're charged with the state jail felony offense of abandoning a child from August 27th of 2021. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily, and because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Jeffries? The paper on the computer? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached in each of your cases is for a cap of 15 months in the state jail prison, which means if I follow the agreements, I cannot give you more than 15 months in state jail. I can give you 15 months, I can give you less. It'll all depend on the information that I get when we come back at sentencing. You have an absolute right to have a jury come in and determine 2 things. The first is determine if you're guilty or not, and then you could leave your punishment up to that jury if they found you guilty. If we go forward this way, you're waiving that and leaving it up to me. And is that what you want to do?
Yes, ma'am. Yeah.
I don't understand.
Cases are together, concurrent.
If I give you prison time in each of these cases, it would run concurrently, which is together at the same time. Okay. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. LeBlanc is not competent?
No.
And also, Mr. LeBlanc, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case? Did I already do that?
Yes.
It's admitted. Okay. I'm going to find, Mr. LeBlanc, that you entered your pleas of guilty freely and voluntarily in each case. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases. Then we'll come back at a later date for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Jeffries. He will present it to me on your behalf when we come back. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay, we'll see you back at sentencing.
Thank you, Your Honor.
Thank you. You're all free to go. Probably so. All right, sir, you're Michael Brasher.
Yes, ma'am.
And Mr. Brasher's case is set for trial to begin with jury selection on June 23rd. Obviously, Mr. Brasher, you were in custody last time you were here, and now you've made bond. And since you've made bond, I hate to move, your case is getting old, but if you've made bond, I expect you to try to hire a lawyer.
That is exactly what I brought here I brought some paperwork to present to the court if you see it. I want to ask for a continuance for that same reason.
So here's what I'm going to do, Mr. Brasher. I'm going to take your case off the trial docket and move it to a designation docket. I'm going to reset it about 30 days. You need to try to get someone hired before that court date.
Okay.
If you do, we'll give you a written reset notice today. Make sure you bring that to whoever you hire, and they'll tell you what to do.
Okay.
If for some reason you cannot hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
I have an attorney. I've spoken with him. He's given me a quoted amount. That's why I brought some of this stuff
Okay.
to show you.
I don't necessarily need to see it. I just need to, I'm going to see what you can do in the next 30 days. If for some reason, and I know you just bonded out, so if you possibly need more time, I understand. When you come back, let me know. If you haven't hired him or anyone else, make sure you visit with plenty of attorneys, bring me those names, or if you have one picked, have that information. If you've made payments, bring me that information, and then we'll discuss your options, okay?
I can absolutely. Would you like his name now? Or?
Who is it? Yeah.
Mark Gonzalez out of Corpus Christi.
Okay. All right. Then make sure also that if that's who you hired, that Mr. Gonzalez knows that your case is old and that we will expect whoever you hire. Hold on a second while I'm talking, please, Mr. Majid. That's okay. Make sure whoever you hire understands that your case, if it's not worked out, is going to be set for trial pretty quickly because it's old. And so a lot of attorneys think they're going to get on and they'll have plenty of time. It's not going to be like that. They're going to get pushed. So you be sure and tell them that, okay?
And yes, ma'am. We've talked about that too.
Okay,
So,
perfect.
He understands that as well.
Okay, if you'll step over here in front of the clerk, she'll give you that reset notice. Thank you.
Copy of that. You're saying here that your notice.
And also, until then, Mr. Matuski, you're obviously still on the case as begin to prepare possibly for trial, but I will take it off the trial docket at this point, just to give Mr. Brasher some time.
Yes, ma'am.
All right.
Thank you, Judge.
Yes, sir. So we need Mr. Jeffries again, I guess, at some point.
Thank you, Brian. Sorry.
Good morning, ma'am. Are you Ashley Broussard? And Ms. Broussard, in cause number 25 DCCR 0175, you're charged with the 3rd-degree felony offense of injury to a child from October 28th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And I have here on the computer a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Also, I'm sure Mr. Kimler went over with you that that type of probation, if you're successful, means you don't have a felony conviction on your record. Do you understand? You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. I also want to make sure, Ms. Broussard, that you understand that after today, I will not accept this plea agreement. If you change your mind to want to plead guilty, you can plead open to the court. It could be to some different agreement, but it won't be this one unless there's some new information that your attorney or Mr. Smith gets between now and trial. Do you understand? All right, then I'll get it set on the trial docket, and Mr. Kimler will begin preparation for trial. You're free to go. Yeah, Mr. Kimler, you filed a motion about bond conditions.
That's right, we can take that up. She was ordered not to have any contact with the child. And there was an interval between the events made the basis of this case and the arrest, I think 3 or 4 months right along, when CPS was investigating the case, where she had custody of the child, or at least was visiting the child.
What?
With CPS.
Y'all can't both talk at the same time.
With CPS supervision without any problems. Then when she was arrested, there was a condition of bond that she not have any contact with the child. CPS doesn't have any issues with her having visitation or contact with the child. We were just asking the court remove that bond condition because it's impacting her relationship with the child. I think the child's development. How old's the child? 3 years old.
Give me just a second. Can you hand me that I'm printing, please?
Who was the CPS investigator? If you have any questions of her, we'll put under oath.
Mr. Smith?
If Mr. Smith has any questions, we'll put under oath.
No, I'm asking what your position is.
It's opposed, Judge.
And again, I would just observe that there was about approximately 4-month period prior to her arrest. There were no incidents.
But that was,
There's a co-defendant in this case, Dalvius Williams. We had a hearing on this. I believe it's an MTRP on Mr. Williams. So you've seen the evidence in this case. I don't know if you recall it, but the child was 2 years old and nonverbal. And showed up at school Friday, everything was fine, shows back up, misses Monday, shows back up Tuesday. The marks are there, and allegations are that those were the only people around her at the time.
And I would just observe that there was a CPS investigation subsequent to that where the child remained in contact with the defendant with no deleterious consequences reported.
no, what consequences?
Bad consequences.
No,
Harmful.
what's your word?
Deleterious.
It's not gonna be my word of the day to learn.
One of those SAT vocabulary.
It's been a long time since I took that. I'm trying to recall that hearing. I feel like that Mr. Williams was maybe more culpable with regard to the specific allegations, not necessarily not turn them in and things like that, but the actual physical.
And then when the police started the investigation on this, she lied to the police.
Allegedly lied. She didn't cooperate. We can agree on that. It was non-cooperative.
The only thing I will do, I will modify the bond condition that you can have contact with the child, but it is only to be supervised. So you are never to be alone with the child, period.
Is that through CPS supervision or is the supervision?
I don't, if CPS isn't involved, I can't order them to supervise. So y'all work on figuring that out, but there has to be another adult, of some adult at all times, not a 16-year-old, an 18-year-old, someone. Okay, perfect. Then I'll let you have visitation so that you can, obviously, I think this is something you will be able to get past. You'll be able to hopefully work towards more than just this, but I want to start off with me feeling comfortable with that until we figure out what's going on in your case.
Just
Okay.
in the interest of specificity, she's only to have contact with the child in presence of the grandmother. What's the grandmother's name?
Dana Williams.
She's
Okay.
only to have contact with the child in the presence of Dana Williams.
Okay, yes, that's the order. Thank you, Mr. Kimmler. Yeah.
Today, we're inside Judge Raquel West's courtroom, where 4 defendants come face to face with the fallout of second chances gone wrong. From probation violations to evading arrest, this isn't just justice, it's accountability, up close and personal. Stay tuned. Every verdict here tells a story of choices, consequences, and the truth that can't be dodged. Story.
Oh, I don't have all that yet. Y'all hold on just a second. Good morning, ma'am. You're Renisha Payan? And will your client waive the formal reading of the indictment?
So,
Ms. Payan, in cause number 24, DCCR 2107, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from August 25th of 2024. And how do you plead to that charge? Speak up. Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? Speak up.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimmler?
Yes.
Do you fully understand them? And it's my understanding that you are pleading guilty open to the court, which means I can sentence you anywhere in the range of punishment. Is that your understanding?
Yes, ma'am.
So y'all signed the post-conviction waivers
Oh, so
on the admonishments, but
Well,
y'all didn't sign them on the, you said it wasn't an agree.
well, I don't even know, is she waiving post-conviction waivers if it's an open plea? I mean, after she's sentenced, if she gets probation, she could waive them then.
You're the one who marked them. No, she can't.
That's what I'm saying. Okay, I'm sorry.
That's why I'm bringing it up.
All right.
Y'all marked that it was a plea bargain. Everything is all marked
Yeah,
incorrectly.
I should have had her sign the post-conviction.
Okay.
I'm sorry. It's force of habit, Your Honor.
And then on that last page, I changed it with everyone's permission to the fact that it's not a plea agreement on the certification of right to appeal.
Thank you, Judge.
Right.
Okay. And I'll mark through. Okay. Okay, so I want to make sure you understand, you have an absolute, so first of all, I can sentence you anywhere in the range of punishment, which is between 2 years and up to 10 years in prison. I can consider probation. It'll all depend on information that's brought to me when we come back for sentencing. You have an absolute right to have a jury, which you're set for trial next week, starting trial on Monday, and let that jury decide if you're guilty or not. And then if they find you guilty, you can leave your punishment up to that jury. If we go forward this way, then you're waiving that. And is that what you want to do? Okay. State, do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
Objection.
It's admitted. Any evidence that Ms. Pine is not competent?
There's none.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Kimler. He will present it to me on your behalf when we come back.
Yes.
All right, you can, on your way out of the courtroom, stop and talk to probation. She's at that desk right there. Okay?
Discovery, right?
Yeah, discovery.
Right.
Right, your discovery, please.
I'm working on it. All right, I need to do the exhibit.
Okay.
Thank you, Ms. Lewis.
Yes, ma'am. Don't forget to talk to probation on your way out. Okay. And then cause number 24, DCCR 2265. We've already gone through this, but you're charged with evading arrest or detention with the use of a vehicle. I have reviewed the pre-sentence report in your case. Based on that report and the fact that there is an allegation, obviously an allegation of a high-speed, very dangerous chase, but in addition to that, there's an allegation that drugs were thrown out of the vehicle during that chase, and that's why I ordered the drug test this morning. It's now 11 o'clock. I ordered this drug test prior to 9 o'clock. You have not been able to go or are refusing to go to the restroom. Based on that, I am going to find that I'm going to assume that you are positive and that it is in the best interest of our community that I raise your bond, which is currently set at, give me just a second to figure that out.
It was at 10,000.
10,000.
Yes, ma'am.
I'm going to raise your bond in your case to $30,000. A condition of that bond, if you make it, is that you wear a drug patch at all times. You will have 24 hours from the time you are released, if you make that bond, to have a drug patch put on. Your bondsman can let you know where to do that. You have to change it every 2 weeks. If it tests positive, you would be right back in custody, obviously. If it's not testable, then it's also going to be considered a positive drug screen. You can go back with the bailiff.
Can I say anything right now?
Not today, not now.
In today's session before Judge Raquel West, we saw a powerful reminder that every choice carries a consequence. Mr. Johnson, charged with evading arrest in a vehicle, learned the hard way that you can't outrun your past. Then came Michael Brasher, back in court for repeated probation violations and jail misconduct, proof that defiance behind bars never earns leniency. Ashley Brossard faced the judge for drug possession and supervision breaches, showing just how quickly relapse can erase a second chance.